when we talk about what's happened between Israel and Iran, I think that's a situation which very much falls within that sort of much more liberal interpretation of the idea of imminence. Okay, because it was seen to be that there was certain quite volatile rhetoric coming from the Iranian regime. And there were some ideas that they were generating enough uranium to produce a nuclear bomb, which of course Israel perceived as a threat to it.
Powered by International Committee of the Red Cross.
Hello and welcome to another episode of Legally Speaking on DawnNews English. This is your host, Ayesha Malik. Today we're going to be covering the use of force under international law. So after World War II, one of the main aims of the drafters of the UN Charter was to seek to restrain the use of force and avoid the horrors of that war. The first purpose of the UN listed in Article 1, Sub-Article 1 of the UN Charter was to maintain international peace and security. So it sought to establish a general and comprehensive prohibition of force, which was not found in the League of Nations Covenant, and it also aimed to set up an organization that would be able to take collective action to deal with threats to the peace or breaches of the peace. There are three key provisions dealing with the use of force in the UN Charter. So there is a prohibition on the use of force in Article 2, Sub-Article 4, to which there are two exceptions. So Article 51 acknowledges the inherent rights of states to individual and collective self-defense if an armed attack occurs, and we'll be referring back to that wording a number of times during this podcast. And then the second exception is that of Article 42, which allows the Security Council to authorize the use of force when the Security Council considers that there has been a threat to the peace, a breach of the peace, or an act of aggression. Jurisprudence by the International Court of Justice also holds that while states are not allowed to use force against each other, except for in self-defense or under Security Council authorization, they also can't use this force indirectly either. And that means through the use of non-state actors. So the provision of weapons and logistical support to a non-state armed group would amount to use of force. And going beyond that, organizing and sending the armed group to conduct an armed attack against another state would give the victim state the right to use force against the state sending the armed group under Article 51. International law is clear. You cannot avoid your responsibilities under the UN Charter by using a proxy force to conduct those armed attacks on your behalf. Now, there are many controversial aspects of this law, as you can imagine, and we're going to focus on three of them in this podcast. So these include, the first one is whether or not anticipatory self-defense is allowed, in that whether you're allowed to use force to respond to an armed attack that hasn't yet occurred. Some states are clear on this. They say that Article 51, the text is very clear. If an armed attack occurs, if it hasn't yet occurred, you cannot use force in response to that attack. However, another group of states say that preemptive self-defense is allowed against an imminent armed attack, in that you're not meant to just sit there as a sitting duck waiting for an armed attack that you know is coming, but the test for that use of force in self-defense preemptively would be the imminence of that armed attack. And that's why when it came to the war against Iraq, there was a lot of talk about WMDs, that they had weapons of mass destruction and that these could be deployed in 45 minutes. The use of that term 45 minutes was very important because it was an attempt to justify this under the preemptive self-defense and that imminence criteria. Now, the last category is preventive self-defense. This is used against threats which haven't yet materialized. The best example of this is Israel's attack on Iraq's Osirak nuclear reactor in 1981, which many states decried as unlawful because it was preventive, in that there had not even been an imminent armed attack that it was responding to. It was in response to a threat in the future which had not yet materialized. The most recent example of that would be Israel's use of force against Iran very recently against its nuclear program. So while some states believe that preemptive self-defense is allowed, most believe that preventive self-defense is unlawful. The second controversial aspect is what if a non-state actor conducts an attack on a state's territory from the territory of another state without that state having sent them or even being involved with them in any way. So the most used example for this is ISIS in Syria in 2014, when ISIS was conducting attacks against other states from Syrian territory. Instead of Syria sending or organizing them or even harboring them, Syria was actually involved in fighting against ISIS itself. From this, we get a very controversial doctrine, which was first used by American academics, which argues that if the state is unable or unwilling to deal with the threat by the non-state actor, victim states of the armed attacks can use force in that state's territory against a non-state actor. In this case, Syria was very willing but unable to stop the attacks by ISIS. This remains a very controversial doctrine. Despite having some state practice to support it, it is definitely not yet hard law. The last issue we'll cover is that of humanitarian intervention. So some argue, particularly after the intervention in Kosovo in the late 1990s, that there is a third exception not found in the UN Charter, which allows for humanitarian intervention in the event of grievous crimes and human rights violations. However, again, many argue that any claim in favor of this exception is dead, as no state is currently arguing for it in Gaza, and there could be no better case. So talking to us today about these issues is Christian Henderson, Professor of International Law at the University of Sussex. I hope you enjoyed the discussion. Thank you so much for joining us.
Thanks very much. It's great to be here.
So I just wanted to ask, to start off with, if you could walk us through Article 2.4 and Article 51 of the UN Charter and how these provisions interact.
Okay, thanks. Well, these two provisions were included in the United Nations Charter in 1945. You mentioned Article 2.4 there. This is a fairly simple or basic provision within the UN Charter, and it's very often seen as the cornerstone or a cornerstone of the Charter itself, because it prohibits states from either threatening or resorting to the use of military force against other states. So states have that sort of protection provided by Article 2.4. So it's a fairly basic provision. It doesn't go into too much detail. It doesn't, for example, allude to any exceptions to that prohibition on the threat or use of force. And that's where Article 51, which you just mentioned, comes in, because Article 51 of the Charter then provides the exception of self-defense. Okay, there's also another exception, which you have to look further into the Charter to find, which is provided by the UN Security Council, authorizing states to resort to military action to, for example, enforce a UN Security Council resolution. So there are two exceptions, I should say, to the prohibition on the use of force. Now, Article 51 and self-defense, that is, of course, the most controversial one, because it's the one that states feel they can resort to without having to go to the UN Security Council and going through all those procedures to try and receive authorization by the Council to resort to force. And it's very controversial because, or one of the reasons why it's controversial is because it contains this phrase, if an armed attack occurs. Okay. And that's difficult to really pin down exactly when an armed attack occurs. Many, perhaps even most, will say that it's when an armed attack is occurring against a state that it can resort to the use of force in self-defense. But others have sort of taken a more liberal interpretation of this particular phrase and given it a more liberal temporal meaning, I suppose you could say, whereby the armed attack may not actually be occurring, but it may have already occurred, okay? Or it may not have occurred at all or begun to take place, but a state perceives a threat from another state or an non-state actor and deems it necessary to resort to the use of force. So they are the main provisions, or the main the prohibition, along with the two exceptions. And I'll stop there, but I'm happy to go into more detail should you wish on those particular aspects.
Yeah, so if we could start off with the notion of if an armed attack occurs, which is very controversial, the wording in Article 51, and looking at that in light of recent events, particularly Israeli strikes against Iran and the notion of anticipatory self-defense. So in your estimation, does that fall under preemptive self-defense? Is that preventive self-defense? And what should the test for imminence be?
Okay, yeah, really good question. I think we should probably just start by saying those terms themselves are a little bit contested and used in different ways. Personally, the way I've framed these things is that we have what we call anticipatory self-defense, which is self-defense which is taken when a state perhaps sees, an army massing on its border, and it's a fairly high certainty that it will be attacked should it not take action to try and prevent that attack from occurring. Okay, so that's where this idea of imminence comes in, and there is a threat of imminent attack unless action is taken to forestall it. Um, More broader than that, so along the sort of temporal scale, then we have, I think, what we call preemptive self-defense. So it's not where we see an armed attack as imminent in the sort of traditional understanding of the word, but it's a more distant threat. Okay, it might be something which they see on the horizon within the next weeks or months or even years. But they have a real or they're under a real perception that this threat is going to emerge at some point. So there's a distinction there between anticipatory and preemptive, and they both seem to try and play on that idea of imminence. But of course, one has a much broader perception of it. When we talk about what's happened between Israel and Iran, I think that's a situation which very much falls within that sort of much more liberal interpretation of the idea of imminence. Okay, because it was seen to be that there was certain quite volatile rhetoric coming from the Iranian regime, and there were some ideas that they were generating enough uranium to produce a nuclear bomb, which of course Israel perceived as a threat to it. Now, it's sort of received from some quarters political support. And states would sort of say in a very general way that Israel has a right of self-defense. But very few states, if any, really tied in what happened with Israel's right of self-defense, because that is a very, very controversial interpretation of imminence and the notion of self-defense in general. So, for what it's worth, from my perception, of course, from my own thinking on this, what happened between Israel and Iran was an unlawful use of force at that particular moment, particularly when we had the IAEA saying there's no smoking gun here at this particular stage. We even had reports that the US authorities as well were saying there's no smoking gun here. So if we don't have that imminence, then of course it's very difficult to say that what they did was lawful.
Yeah, and I think Marko Milanovic put it as a two-part test, that you would have the nuclear bomb and the threat would be that you would use it against Israel, both of which were unfulfilled in this case.
Yeah, exactly. Yeah.
And I think so, again, just going back to that term, if an armed attack occurs, and you referred to this in your answer to the first question, which is there is a halting and repelling school of thought, which says that the armed attack has to be ongoing in the form of that attacks are currently ongoing or the occupation is ongoing for you to have the right to self-defense. And then you have the trigger theory, which says that even if the armed attack is finished, you do have the right to respond against future attacks, be they imminent or not. For me, the first school of thought, I think, takes away too much from states who have suffered an armed attack. And I don't think really accords to the text of Article 51, which says if an armed attack has occurs, not, one that is occurring. What do you think about that?
Yeah, I think we have to take a fairly pragmatic approach to this. I think we have to do that, but we have to take on board, a collective views of states as to how they see this. If we're going to talk about international law, I mean, states will always do things from an operational point of view and assert rights, whether or not it accords with the generally accepted interpretation of international law. But I think now we have situations that do arise whereby there are, for example, what we might call pinprick attacks, okay, whereby a state is suffering a series of attacks by a particular actor, whether that be a state or an unstate actor. And perhaps it is unrealistic to expect them for every time to sustain those attacks and not be able to do anything about it, have their hands completely tied. So I think that falls within that sort of situation you're referring to, where there might be seen to be a continuing armed attack there, even though it's in small segments or installments. And I think then at that point, a state could justify that there is a necessity, because we have to look at those two customary requirements around self-defense, a necessity and proportionality. The necessity to act in self-defense to forestall future attacks. Now, that also has to be done drawing upon the other criterion of proportionality. So what they do should be sufficient and only what's necessary to put an end to that continuing range or series of pinprick attacks. But I think we need to sort of be quite mindful. Although I suppose I'm a restrictionist at heart, I'm also quite mindful of the fact that obviously states things are different now than they were in 1945, and I think state practice has evolved, and we do need to take into account these different types of threats which states I think face now.
Yeah, and primarily those against non-state actors. So looking at it in the sense of the test for attribution that the ICJ laid down in Nicaragua in 1986 and how much that has changed in state practice. From the Global South position, the unable unwilling doctrine is incredibly problematic. It's controversial, even though Global South states have engaged in it. To what
Yeah,
extent,
yeah.
especially in light of, I mean, India and Pakistan, and I know that you wrote about India and Pakistan in 2019 as well. We've again had this notion of that the attribution link was not satisfied, and yet um, another state used force against non-state actors in that state's territory. So how much do you think going on from 9/11 and the first use of the unable unwilling doctrine, sorry, was 2014? How much do you think that has gained acceptance among states?
Yeah, it's a really good question. Okay, just to go back to the Nicaragua standard, I think, first of all, and this idea that for the actions of non-state actors to be attributed to a state, there has to be, or they have to be under the effective control, more or less, or receiving direct instructions from a particular state. Now, it's a difficult one because what we see today with terrorist groups and the way the relationship is between terrorist groups and states, you just very rarely can make out the idea of effective control being sustained. I mean, there is an alternative approach there, which, of course, the International Criminal Tribunal for the former Yugoslavia drew upon, which is this idea of overall control. So, but whereby a state would not necessarily be issuing direct instructions, to non-state actors, but there will be a relationship there sufficient to sort of indicate that they have a say over what's going on and providing them with the means to carry out particular attacks. Now, with the unable and willing standards, we sort of have to position that somewhere, I think, between those tests, because states who are invoking this idea that a host state is either unable or unwilling to take the necessary action to forestall these attacks by these non-state groups, they're not making the claim that they are under effective control. Indeed, if we go back to 2001, when the US took action against Afghanistan, there was absolutely no claim made there that the Taliban were acting in effective control of Al Qaeda. If anything, it was the other way around, and Al Qaeda perhaps was wielding more power there. But there's this idea that these non-state actors are located within your territory, and you, under the rules of state responsibility, have a role here to act with due diligence to take action against these particular non-state actors. And if you don't, then we will invoke our right of self-defense under the basis that it's necessary to take action against them. So we have definitely evolved, I think, a little bit away from this idea of effective control from the Nicaragua case. But I think this is one area of the law which is very much in flux yet, because we have a group of states, mainly Western states, who seem to accept this idea of unable and willing. The UK, the US, perhaps Germany as well. And then we have a lot of states, perhaps, from the global south especially, who are just not willing to go there at all with unable and willing. So we're in this position where some will just claim that it is the law, and others will absolutely refute that. And I think we are in a position whereby the law is being worked out over exactly where it stands on this particular issue. I just don't think we can say that one position is strictly correct over the other, because there are two very polemic positions being expressed here, and I don't think necessarily either of them are correct.
Okay, yeah, and going back to, so another area of contention between the global north and the global south is the issue of humanitarian intervention, a potential third exception found in custom, which is not under the UN Charter. From the global south position, currently, is humanitarian intervention dead? Because there could be no better case for it than Gaza.
That's a good question again, and a very complex one. Humanitarian intervention the idea itself has never really, in terms of a legal right of states to intervene for humanitarian purposes outside of the context of the UN Security Council providing authorization, has never really been there, because we've only ever really had one state who's expressly stated that it is a legal right which they possess, and that's the United Kingdom. Every other state, even the US and some of the UK's other allies, have never expressly stated to be a right. It's always been justified because they're trying to enforce UN Security Council resolutions, or perhaps they're intervening to try and put an end to the use of chemical weapons, for example. But an actual right of humanitarian intervention is just something which has never really been raised by states other than the United Kingdom, which it has done on several occasions. Of course, we have this responsibility to protect notion, which came in sort of in the early 2000s. And there was some hope that that might give some legitimacy to an idea of humanitarian intervention or a legal right of humanitarian intervention, but it never really did, because it was always been interpreted as being just the UN Security Council ultimately being the one to authorize such an intervention for humanitarian purposes. So that's never really found favor either. And when we're looking at what's going on in Gaza now, or something which we're all looking on in horror, the idea that any state would intervene militarily, at least for humanitarian purposes, has never been on the cards. I mean, I don't think any state has ever indicated that that could be a possibility for all sorts of legal, practical, political reasons. And it's more about, the issues are more about the rights and wrongs of providing military support to one group or the other, given their particular actions within this particular conflict and the way they are designated by states themselves.
And just going further into the Israel and Gaza conflict and looking at that in the context of self-defense, do you think that Israel has the right to self-defense in territory that it occupies? I know that people who argue against rely on a very, very ambiguous paragraph from the ICJ's 2004 advisory opinion, which doesn't really, provide that much meat and bones to the issue. So I wanted to know what you think.
Yeah, I think when we're talking about the right of self-defense in terms of an international legal right of self-defense as found in Article 51, then yeah, again, with the ICJ, I don't think there is a right to invoke that. That's not to say that Israel can't use methods to try and protect itself, but it wouldn't be under the international legal right of self-defense as found in Article 51.
Okay. And my last question, our first podcast was about how there's such little hope that people hold in international law, given what we've seen over the last few years, especially starting from Russia's invasion of Ukraine in 2022, and now even more recently, India, Pakistan in May 2025, and Israel, Iran. What do you think? Is there still hope that we can have in the UN Charter, despite the blatant acts of aggression which go against the founding principles, the preamble, and the object and purpose of the UN?
Yeah. There's no doubt we're living in really troubled times now, and I think not just international law, but just basic ideas and notions of humanitarian spirit, I think, are really coming under direct attack from all sorts of angles, whether it's the nature of particular governments, the way other governments are responding to those particular governments and their actions. It's very difficult to see positivity, I think, and any real value in international law in that. I've always said, though, that if we start thinking about international law as just something that can or should be upheld and enforced consistently against states and other actors, we're always going to be disappointed. At the very least, and this is something which we do continue to see, that international law provides a means of discourse between different actors about what's taking place. Now, some would say, well, yes, that's fine, but of course, states just see international law purely as through instrumentalist means and just as a way of justifying the things that they want to do. Yes, there is certainly that element to it, but it also provides a baseline of standards which states, either through treaties or as existing customary international law, have agreed to, or at least applies to them in some ways. And it provides that means of discourse which I think we would be much worse off if we didn't have, despite all, of course, its limitations that we see. So I think there is hope for international law in that sense. And I do think, things operate in a very cyclical way. And I just hope that we're at the very bottom of this particular cycle and things will improve in the years, potentially decades to come. So we're still in the United Nations era, and that in itself is a success. And nobody, at least explicitly, has called for the end of the UN Charter of the United Nations. At least no states really have called for that. I think until we get to that point, there's always going to be some hope there.
Yeah, I agree with you. Thank you so much for joining us and for talking to us about all of this.
You're very welcome. It was a pleasure. Thank you.
I hope you enjoyed that discussion on international law and the use of force as it pertains to self-defense, and I hope you can understand why a lot of these issues are very controversial. There are states advocating for narrow exceptions to the use of force, and those arguing for very wide ones, including Israel in its argument in favor of preventive self-defense and its argument that self-defense can even be invoked in territory that it occupies. We'll only know from further state practice the extent to which the law against war can retain its integrity with states attempting to carve out these very large exceptions. Join us next week for future episodes of Legally Speaking. This is your host, Ayesha Malik.
Powered by International Committee of the Red Cross.